Hi, I'm Malia Zimmerman, and I'm here with Ilya Shapiro with the Cato Institute, and he is an expert on Obamacare and the lawsuits that are being challenged around the country to challenge this mandate. Ilya, tell us about what your involvement is.
Sure. Well, ever since the legislation was passed about 2 years ago, I've been writing about it, going on across the country to debate the constitutionality of the individual mandate and other aspects, filing briefs. Cato, have now filed 10 briefs, including 4 at the Supreme Court, and we've organized other groups and state legislators as well, so that they have the information they need to talk about this, because the individual mandate, I mean, Obamacare generally is unpopular and increasingly so since it was passed, but the individual mandate is overwhelmingly unpopular. We're talking about completely neutral surveys by the AP that reveal 75–80% opposition among the American people. And now this thing is coming to a head. It's finally at the Supreme Court. There's going to be a historic 3 days of argument at the end of March, with a decision expected at the end of June.
So what took us to this point? We have the mandate, meaning buying insurance, is that right?
Right, that's the central part that's being challenged, the requirement that everybody buy a health insurance policy, because the whole rest of the reform, the national reform requiring insurers to cover people with pre-existing conditions, making premiums not based on individual risk but kind of on a community rating, all of the Medicaid reforms, all of this is triggered, doesn't work without the individual mandate. So that was challenged. There's about 3 dozen lawsuits. The main one, the one before the Supreme Court now, involves 26 states, as well as the National Federation of Independent Business and a couple of individuals. But even beyond the mandate, which is unprecedented, the government has never required people to buy a particular good or service in the marketplace. I mean, you look at the height of the New Deal or the Civil Rights era. I mean, something like this has never been done. But beyond that, there's going to be 2 hours of argument on that. But beyond that, they're looking at, if it falls, how much of the rest of the legislation has to fall that's tied to it, or does all of it fall because Congress wouldn't have passed any of it, as well as a Medicaid expansion issue. That is, the states are claiming, with good measure, I think, that the expansion of Medicaid that's being required of them into creating new exchanges, covering more people, spending more money, is coercive and violates federalism, violates the 10th Amendment, because the federal government is saying that all the states to receive any federal Medicaid funds, not just new ones, have to do this. And the states are saying, well, look, when we signed up for Medicaid, be it in 1965 when it was created, or in 1982, that's the last state, Arizona, that joined, it was a completely different program. And now you're trying to transform it in this way, and we're stuck. We're between a rock and a hard place. We can't leave, but we can't really afford this new stuff that you're forcing on us. So there's a lot of complicated issues, but ultimately it comes down to whether the federal government is exceeding its powers under the Constitution, because if it is, then it's no better than an armed gang. If the federal government, which gets all of its powers that are listed right there in Article 1, Section 8 of the Constitution, look that up. If it's going beyond its power to regulate interstate commerce, for example, then it's illegitimate. And these are powers and rights and liberties that are best left to the states and to the people with their own sovereignty.
We've heard talk about some of the judges maybe being asked to recuse themselves, maybe one judge in particular. Have you heard anything about what that outcome will be?
Yeah, those on the left are saying that Clarence Thomas should recuse. Those on the right are saying maybe Elena Kagan should recuse. I've looked at all of the FOIA documents, the Freedom of Information Act documents that have come out about these issues, and I don't see a smoking gun. The things with Justice Thomas, it's his wife was involved with things. I mean, that's really frivolous. With Elena Kagan, she was Solicitor General when the litigation started, but the SG's office, the head government lawyer, doesn't really get involved until the appeals start, and she told her deputy to be in charge of this anyway. We've already seen rulings on the case. None of them have been recused in those rulings. So, as just basic facts on the ground, I don't think there will be a recusal. And while the calls for Kagan to recuse aren't frivolous, I don't think it's a compelling case, and we'll ultimately see all of the full court up there.
What do you predict of the outcome? Are you willing to predict something?
Sure. I think the swing vote, the conventional wisdom, which I agree with, is that the swing vote is Justice Kennedy, and I think it's more likely than not that he'll vote to strike down the individual mandate. It'll be a 5-4 decision, and at that point, Chief Justice Roberts becomes the swing vote in terms of severability, which means how much of the rest of the law has to fall. And it'll be somewhere between the government's position, which is that along with the mandate have to fall this community rating and guaranteed issue, as I described, and the plaintiff's position, which is that the whole thing has to fall. There are several, as I like to call them, rings of hell, referring to Dante, with individual mandate at the center of it, but there's other parts that are more and more connected to it. So we'll see certainly the central parts of the legislation fall, and I think that's a good thing. It doesn't mean that our status quo healthcare system is in good stead, but I think Congress will need to go back to the drawing board and do something that's not just good public policy, but actually within its powers to do.
And the final question is, how important is the outcome of this?
If the individual mandate is allowed to stand, then I don't see any principled limits left on federal power. And the next time there's a financial crisis or a housing crisis or an auto industry crisis, the government will just be able to tell people to buy a particular type of financial instrument or a Chevy or what have you. I mean, this really blows up the idea of limited enumerated government, and it's dangerous in a whole lot of ways. Not healthcare is the tip of the iceberg.
So how can people follow your work on this case?
Well, I blog a lot at Cato's website, and I have a bio page there. You can just go to cato.org and look me up as one of the experts there, or just Google my name. I have a lot of videos up, briefs, writings, and including debates that I've done in Hawaii. I think one of those is up there.
And will you be able to attend the discussion?
I think so. I'm pulling some strings, but I think I will be there.
All right. Well, Ilya, thank you. We'll follow your work on this case, and thank you for joining us today.
Great.
Thank you.